So from the Daily Princetonian, I'm Sandeep.
And I'm Katherine.
I have the privilege today of introducing Professors Allen Guelzo and Matthew Karp. Professor Guelzo is the director of the James Madison Program Initiative on Politics and Statesmanship and serves as a senior research scholar in the Council of the Humanities at Princeton University. He's a New York Times bestselling author and has written extensively about the American Civil War era. In 2018, he was named a senior fellow of the Claremont Institute and currently serves as a trustee of the Gilder Lehrman Institute of American History.
And Professor Karp is an associate professor of history at Princeton University. He received his PhD in history from the University of Pennsylvania in 2011 and studies the United States Civil War era. His first book, which explored the impact slavery had on U.S. foreign relations before the Civil War, won the John H. Dunning Prize from the American Historical Association, the James Broussard Prize from the Society for Historians of the Early American Republic, and the Stuart L. Burnout Prize from the Society for Historians of American Foreign Relations. Professor Karp continues teaching courses on 19th century United States.
In today's interview, both Katherine and I will discuss with Professor Karp and Professor Guelzo judicial supremacy and politicization of the courts, the implications Judge Amy Coney Barrett's possible confirmation could have on the future of the Supreme Court, and the lessons we can glean from this unusual situation. So my first question is to both Professor Karp and Professor Guelzo. What is judicial supremacy?
Well, I guess I'll jump in. Judicial supremacy really rests on two things. One is the fact that the Constitution itself declares that it is the supreme law of the land. Connected with that is the authority of the Supreme Court in interpreting the Constitution in terms of legislation which comes before it for review, either from the federal level or from the states. The principle of review having been established as early as 1804 with the case of Marbury versus Madison. So judicial supremacy really largely rests on those two posts, the Constitution and the Supreme Court's own assertion of the power of review of legislation from Marbury versus Madison.
Yeah, I would just say, I guess my understanding of that term, although I guess judicial supremacy has, can come up in a number of different contexts, is sort of more. I think of Professor Keith Whittington's book, a professor in the political science department here, politics department here, about judicial supremacy as a kind of shorthand for that sort of embodies in a sense an argument about the court's powers, that the mere existence of some sort of judicial review, which isn't really actually in the text of the Constitution itself, but as Allen says, was sort of claimed by the court in Marbury versus Madison, that judicial review can be construed in a number of different ways, and what this country has developed especially in recent years since the Second World War is something closer to judicial supremacy, which actually takes not just the principle of the court will the court will sort of examine legislation for its constitutionality, but will in effect, frequently and regularly and vigorously act to sort of as a sort of a final arbiter of that question, a kind of a sole arbiter in some ways, and assume a much greater power in that respect than at least some historians argue it had in previous eras. So I see judicial supremacy as a sort of as an arguing term rather than a sort of a neutral statement of the case. I don't know if Allen agrees or not.
No, I think you're right. There is, I've talked about these two meanings of judicial supremacy, but there is an implied meaning, and I think this is what Matthew was pointing us toward, and that is between the three branches of government, we normally talk about a separation of powers. And the image we often get in a very offhand way is that the executive branch operates in one silo, the legislative branch, the Senate and the House of Representatives operates in another silo, and the Supreme Court acts in a judicial silo. Well, there are two problems with that. One is that examine the Constitution carefully. There actually is a degree of overlap in the silos. They're not hard and fast. And even Madison himself acknowledged this in the Federalist Papers. I think it was Federalist 46, where he said there's going to be a certain measure of overlap between the branches. But more than overlap, judicial supremacy has also been attached to this implicit jockeying which has happened over the history of the Constitution between the branches. Far from being entirely separated and existing in different universes, the branches, in a way unarticulated by the Constitution or any other document, the branches have jockeyed with each other for a kind of supremacy. They have tried to outbid each other in terms of power. So there have been periods in American history where the executive branch has seemed to exercise kinds of unilateralism over against the legislative branch and the judicial branch. There have been other periods where it's the judicial branch which has seemed to have the initiative. And then, of course, there are moments when the Supreme Court, quite literally, bolts ahead and is moving in directions that are clearly critical of what has been going on in the executive branch and in the legislative branch. So take it in this third sense that Matthew's talking about of judicial supremacy. What you have is this slightly unseemly, maybe not slightly, but it's still not viewed explicitly in the Constitution, a situation in which the branches are trying to edge each other out in terms of who has more authority to speak to particular situations. And that becomes a form of judicial supremacy.
So just to follow up on that, is there like a defined hierarchy of power then, or does it, like you said, flip around? Is there like supposed to be a resting state?
I mean, I would say this is a history shows that this is contested, like everything else like many other things about the Constitution. And I mean, for one, I'll just put cards on the table here, since we're connecting historical to political questions. I'm highly critical of judicial supremacy. I don't think that in the way that it's currently construed, it serves democracy or the Constitution. I mean, we've had in the last couple days, this slightly, to me, absurd spectacle of these elected legislatures pleading to a kind of unelected life tenure judge to please just give us a few hints about whether you will overturn what your opinion on the laws that we as the people's representatives have passed. Will you please give us some inclination of what you and your high and mighty majesty will do? And then the judge, in response, kind of blithely refusing to answer any of these questions and saying she has nothing to do with political questions, or making the laws, but only deciding individual cases. And when Judge Barrett says that, I can only think, if only that were true, but in practice, in our constitutional practice, the Supreme Court has not simply decided cases. It has set up legal frameworks that organize the legislative practice in all 50 states and in the US Congress. These Supreme Court precedents, which routinely overrule state laws, federal laws. I mean, we can get into all of the political things that the Supreme Court has overruled just in the Rehnquist and Roberts Court era. You don't even have to go back to the before that. They all understand the Supreme Court to be the sort of sole arbiter of the Constitution, and thus grant the court kind of power to act as a super legislature. I think that's the situation we find ourselves in now, an unelected, basically in a sort of a lordly high council that has the right to sort of pass its stamp or not stamp on any piece of legislation that the people choose to pass. And I think this is historically something that has waxed and waned, as Allen says. And I think, this is something that was not, I think Dred Scott in 1857, the famous decision, if you want to talk about Lincoln later, which overturned the Missouri Compromise, in effect, was, I think, only the second time the Supreme Court had actually overturned a federal law in about 60 years. This was not like a routine practice where the Supreme Court was constantly shutting down, legislative democratically passed legislation. This was not understood to be the case. And I think the Republicans, led by Abraham Lincoln, objected to this, to the premise that the Supreme Court would be inserting itself into political questions in this way and presuming itself to be the final arbiter of political questions. So I think, and we can take that history backwards and forwards. The court has fought back, et cetera, et cetera. But I don't take our current situation to be the best of all possible worlds in terms of where the court power stands, and certainly not the only of all possible worlds within American constitutional practice.
Yeah, it has shifted significantly back and forth over the years. It seems to me, and here this is my reading of the Constitutional Convention and the ratification debates. The article in the Constitution, Article 3, describing the federal judiciary, is the shortest and, in a lot of ways, the most vague of all the provisions of the Constitution. And it seems to me, from reading the Constitutional Convention debates, from reading the ratification debates, that what was at least was originally expected in creating the federal judiciary, and especially the Supreme Court, was that the Supreme Court would act to restrain state courts from doing the kinds of things state courts had done under the Articles of Confederation, especially the state courts in places like Rhode Island, which earned the nickname Rogue Island for the behavior of its court system. But very quickly, once the Constitution is in place, the federal judiciary begins to take steps in a different and more aggressive direction. And significantly, the First Amendment to the Constitution, after the Bill of Rights, after the first 10 amendments, First Amendment to the Constitution is an amendment to clip the wings of the federal judiciary. This emerges out of a case known as Chisholm versus Georgia in 1793. And the 11th Amendment wants to restrain individual citizens of the United States from suing the state governments of states other than those which they live in. Because the old anti-federalist opposition to the Constitution said, wait a minute, this was never what was in view with the Constitution, so we have to repress this. And so the 11th Amendment is put in place. Well, the 11th Amendment gets into place. What happens after that? The Marshall Court comes back with Marbury versus Madison, asserting judicial review of legislation. So you get a zigzag right from the very beginning of the history of the court, in which people want to diminish the notion of judicial supremacy. Other people want to increase it. And I think Matthew's entirely right. Dred Scott is one of the most striking examples, I would almost say one of the most infamous examples, of an assertion of judicial supremacy at the very top. Because what's going on in Dred Scott is Chief Justice Taney basically saying, you guys in Congress have not been able to solve the slavery question, especially slavery in the territories. The executive branch hasn't been able to solve this particular question. So we, the judicial branch, we will step in and offer a comprehensive solution to the question of slavery in the territories, which of course is what Taney proposes to do in Dred Scott, thinking that he is going to, by this decision, he's going to settle the whole question. Well, obviously he doesn't, but the expectation was this, the judicial branch will step in and do what the legislative branch and the executive branch have thus far been unsuccessful in doing.
Yeah. So Professor Karp, you wrote an article for Jacobin magazine entitled How Abraham Lincoln Fought the Supreme Court, which is what you guys have just been talking about, citing that court's ruling on slavery. So can you explain in some more detail that moment in history and why it's relevant today?
Yeah. I mean, I think Allen summarized it pretty well there too, just to get us started. That's certainly what Taney was doing. I think obviously there's some historical debate about the extent of his sort of collaboration with Democrats in Congress and Washington about whether this was Abraham Lincoln famously accused Roger Franklin, Stephen, and James of organizing this Dred Scott ruling behind the people's backs as part of the slave power conspiracy, which was going to operate through the courts and establish the kind of pro-slavery in effect covertly establish the pro-slavery rule, in all of the Western territories, ban the possibility through of the people choosing to exclude slavery from those territories. So yeah, I mean, this inflamed the North. This was a bald-faced assertion of the court's authority into political matters. And Republicans, I mean, what I find striking about this is, and I think this history is not so well known in the contemporary climate, is the extent to which the Republicans in the 1850s, in response to this like bold-faced assertion of pro-slavery power in the courts, responded not simply by saying this question was wrongly decided and we will hope to get a better decision later. Some of them said things like that, but a lot of them went much further and attacked the court itself as a citadel of slavery. It was a disproportionately Southern and a Democratic court. Attacked the courts, mocked the court's pretension to sort of exist above politics, pointed out that all of the courts, the court judges were mere political appointees like any other political appointees, and that the court served a political function. And, as Hannibal Hamlin said, Lincoln's vice president, the court has the authority to decide cases, not political questions for us. And this is a view that Lincoln came very close to himself supporting in, it's a bit more ambiguous, but in his inaugural address, where he famously said, I could just read the line here, where he says, if the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. So, I mean, the premise of the entire Republican Party before the war is that the court does not have the final say on the meaning of the Constitution or a hot-tempered political question like the extension of slavery. In fact, the court is part of a larger kind of practice of constitutional argument, which is still being sorted out. And when the Republicans got into power, they didn't do the most radical things that they had discussed, such as the New York Tribune wanted to create 13 justices. There were a lot of court packing plans and so on that were feverishly debated. John Hale from New Hampshire wanted to just simply abolish the Supreme Court. They didn't do those things. They did add a justice. They reorganized the basis of the circuits so that there would be more northern circuits than southern circuits. That meant that there would be more northern than southern justices appointed in the future. And then but I think most fundamentally, the Lincoln administration, and I don't know if Allen will agree with me on this, they've just simply sort of disregarded the court precedents that they disagreed with. Like, so the Dred Scott, when Congress passed a law to abolish slavery in the territories, that had been ruled unconstitutional by Dred Scott, which was, as Judge Tawney proclaimed, the law of the land. No, it wasn't, because Congress and the president said it wasn't, and they just simply disregarded that law. So, I mean, I think I feel like this history is worth remembering in a lot of ways, but one, maybe at the most elemental base level, even removing some of my own political preferences here, it's worth remembering that these questions are contested, and that these the final and sole authority of the Supreme Court has often been challenged, even by some of especially by some of our sort of most eminent political leaders.
I think it was an interesting moment when Lincoln delivers that inaugural, because he's standing on the east portico of the Capitol, and he's just taken the oath of office from Roger Taney. And Taney is sitting there listening to Lincoln talk about the court in exactly these terms. I'd love to have seen the look on Taney's face. In fact, there's an even more pointed moment. Lincoln talks in the first inaugural about the enforcement of the fugitive slave law. And as part of what you might say a concession that he wants to make to Southerners, he says, well, I will work as hard as anyone to the enforcement of the fugitive slave law, because it's a law there in the books. My obligation from my oath is to enforce the laws. But, Lincoln adds, we should do it with a due respect for due process. Due process. Due process is something that only applies to citizens. But citizenship was exactly what Tawney had denied to Black people, not just slaves, Black people in general, in the Dred Scott decision. So in saying that, Lincoln is putting this little needle into Tawney and Tawney's jurisprudence, and they're both there within swatting distance of each other. So it is a really peculiar moment that way in the history of this question about judicial supremacy. You know, Lincoln actually talked about the Dred Scott decision only a few months after it was published, and as Matthew was saying, the Dred Scott decision created a tremendous turmoil in Republican ranks, and not the least so for Lincoln himself. So Lincoln has to explain about the Dred Scott decision. You know, what am I going to do about it? How should Republicans respond to this? And as Matthew was saying, in the first inaugural, he's saying, let's not get carried away by this notion of judicial supremacy. In 1857, when he's talking about Dred Scott, he says very much the same thing. We think the decisions of the Supreme Court should be abided by, but only, he says, when fully settled. And what he means by fully settled, he really sets up quite a set of bars for what should be judicial precedent. He says in a speech he gives in Springfield in June of 1857, for a decision to stand, it should have unanimous concurrence of the judges. And of course, Dred Scott was not a unanimous decision. It was a 5-2 decision. It should not have any apparent partisan bias. Well, of course, the loaded term there is apparent. It should be in accordance with legal public expectation, and Lincoln doesn't define what that is. It should not be based on what Lincoln calls assumed historical facts, because he's going to go on to critique Tawney's use of history. And what's more, the case should have been before the court more than once, should have been affirmed and reaffirmed through a course of years. Only if it had gone through all of that process, Lincoln says, should we regard a judicial decision as a supreme one. And that is really setting the bar for judicial supremacy very high. When he becomes president, I mean, again, picking up with something Matthew said, actually, I'll take it a step further. Maybe I'm putting this a little too vehemently, but Lincoln basically ignores the Supreme Court. Roger Taney tries to put a wrench into the works of the Lincoln administration almost at the beginning of Lincoln's administration, when Lincoln issues a suspension of the writ of habeas corpus. This was after the riots in Baltimore, where federalized militia were attacked by pro-slavery mobs in the streets of Baltimore. Lincoln suspends the writ of habeas corpus. One officer of the Maryland militia, John Merriman, is arrested and imprisoned in Fort McHenry by military authority, and Taney issues a writ of habeas corpus for him. When that writ is refused, Taney writes a document called Ex parte Merriman. Now, he tried to make this sound like it was a judicial decision. When Taney writes this, he says, from the chambers of the United States Supreme Court, trying to make it sound as though it's got the whole court's approval, when actually it's really just Taney's personal opinion. But Taney, in Ex parte Merriman, lays out that Lincoln has no authority to suspend the writ of habeas corpus. Lincoln doesn't have, the military doesn't have the authority to do this, just should be a civil matter, and so on like that. Lincoln's response, and this is what Taney really hoped. Taney really hoped that Lincoln would take action and go before the Supreme Court and have the question of Merriman's arrest adjudicated. Lincoln simply declines. He doesn't pursue it. And Taney is left a little like Wile E. Coyote out there, off the edge of the cliff, spinning his wheels or his legs, and nothing is happening. Lincoln only responds to Taney in the special message he sends to Congress on July 4th, 1861. From that point on, Lincoln does his very best to keep matters out of the federal courts. One federal judge who tries to put his oar into this, a judge in Washington on the DC circuit, William Merrick, tries to issue writs of habeas corpus for underage enlistees in the Army. These were young kids who, they were 16 or 17. They enlist, their parents try to get them out. The Army doesn't want to let them go. So Merrick issues these writs of habeas corpus. What does Lincoln do? He puts Merrick under house arrest. And Secretary of State Seward, in fact, suspends the payment of Merrick's salary, which is an explicit violation of the Constitution. And the ultimate solution that they come to in 1863 is that Lincoln and the Republicans in Congress dissolve the circuit on which Merrick was appointed. They get rid of that court and they create an entirely new circuit court for the District of Columbia. So Lincoln's score on judicial supremacy that way turns out to be a very low one, and yet he always was haunted by the fear of what the federal courts might do, especially to the Emancipation Proclamation. He had an ongoing anxiety about what intervention the federal courts might try to stage in terms of interfering with the application of the proclamation. And that's in fact people sometimes read the Emancipation Proclamation and they wonder, why is this thing so dull and boring? Why does it begin with the word whereas? This is the man who wrote the Gettysburg Address. Couldn't he have done something a little bit more eloquent? Well, the reason the Emancipation Proclamation is written the way it is it's written to close off any legal possibilities of contest in the federal courts, because Lincoln is constantly haunted by the fear that the federal courts are going to get their oar into this. And any appeal of the Emancipation Proclamation, of course, is eventually going to wind up in front of Roger Taney. That's one reason why he presses finally for a constitutional amendment to end slavery. That's what he regards as in his words, as the king's cure for all the evils, because he is still in this very adversarial position regarding the federal courts on emancipation.
Yeah, two things I just pluck out of that that basically just as a corollary to what Alan said. The extent to which Lincoln succeeds in simply sort of ignoring the precedents and then even the active proclamations of Taney and Taney's court, and sort of effectually, not just Lincoln but Republicans in Congress too, kind of muzzle the court and sidestep it. I think they demonstrate, a claim that Keith Whittington makes in his book, The Political Foundations of Judicial Supremacy, that even though the judicial branch may at times sort of arrogate itself various, powers and sort of claim for itself, enormous authority, that the foundation of its power, however it's construed, whether it's, Federalist 78 says we can do whatever we want, however, whether it's some sort of originalist interpretation, or whether it's however, whatever the logic of that claim of judicial supremacy is made, its foundations are ultimately political. And in the sense that Taney lacked the political capacity in the Civil War North to overrule the super dominant Republican and Unionist party. Now, that didn't mean that there weren't real concerns, as Professor Guelzo says, as Alan says, about emancipation and so on. And in fact, some of the dissenting justices in Dred Scott, even the Northern justices, didn't think the Emancipation Proclamation was constitutional. So they did need to pursue the amendment and so on. But I think that basically the point is the landscape of political debate about this, the landscape, the sort of even the shape of judicial power itself sort of depends on politics. And I think that's a useful lesson for us to think about when we think about the court's power today, to some extent, that to whatever extent the Supreme Court has this enormous authority to be the sole and final arbiter of the Constitution and act as a super legislature, that power is itself political and can be challenged politically. I don't know if it can simply be challenged judicially, which seems to be the inclination of a lot of people these days.
So if as you said, it's dependent on politics, is there always going to be like a party that's disappointed at any given time? And do you run a risk of politicizing the courts? Because from what I understand, that Lincoln, he fought the courts, but he also kind of did the same thing when he was president.
Yeah, everyone deplores the politicization of the judiciary, and everyone practices it. It's one of those it's one of those things in American politics, where on the one hand this is the theory, but this is the practice. Um, you look at the record of Lincoln's judicial appointees, and there what you see is a very political environment for appointments to the federal benches. Uh, Over the course of the Lincoln administration, Lincoln appoints 4 associate justices. You look at those appointments, and they are all very political. I mean, he even appoints his old former judge from the Eighth Judicial Circuit in Illinois, David Davis, to the Supreme Court. This was the man who'd been his campaign manager at the Chicago convention where Lincoln was nominated for the presidency. And in fact, David Davis was the executor of Lincoln's estate. Well, Lincoln nominates him to the Supreme Court. And he does the same thing with Noah Swain, does the same thing with Stephen Field. I mean, these are very political appointments. All the appointments are anti-slavery appointments. And when in 1864 he appoints or nominates Salmon Chase as Chief Justice, he does it, as he says very explicitly, because he's confident that Chase is going to be the man who's going to protect emancipation and the Legal Tender Act. So his nomination of Chase had very political contents as well. Even if you look down at the district level where Lincoln makes appointments, over the course of his administration, he makes something like 27 judicial appointments filling district judgeships. They are all very political. Some of them, in fact, oddly enough, some of them are actually personal friends of his. He appoints 2 of his old legal buddies, so to speak, from Illinois, Archie Williams and Mark Delahaye. Delahaye in particular is something of a head scratcher because Delahaye was not the brightest bulb in the legal chandelier, but he was an old friend of Lincoln, so he gets this appointment to federal district judgeship. Many of the other judgeships, these are people who are connected with Lincoln in some way or another. He appoints David Carter to the new District of Columbia district judgeship. Carter was the man whose delegate votes at the Chicago Convention were the ones who put Lincoln over the top for the presidential nomination. So his appointments are very political. He is very conscious of politics in doing it. And his appointments to the bench are very much with a political view in mind, and that is, how can this new Chief Justice protect the 2 most important aspects of the war process, which is emancipating slaves and legal tender to fund the war.
Yeah, Sandeep, I would just say to take your question even in a slightly more abstract way, that this question of politicizing the courts is, as Allen says, it's rhetoric. How do you politicize something that is inherently political? This is all political. And in fact, I would go further. I would say, necessarily so. And I would go further. I would say that actually the rhetoric of the need to depoliticize the court, or the rhetoric that imagines the court outside of politics, is itself a political rhetoric of judicial supremacy that is utilized often by the judicial branch and its defenders. I mean, you can see it. You see it with in the Roberts court. John Roberts described himself as an umpire, calling balls and strikes. You see it with Judge Barrett, who is in some ways, I think, portends an even more aggressive, championship of judicial supremacy. Although it's ambiguous, but these are all people who have no problem as judges transforming the landscape of American law. That is, law enacted in statute by Democratic majorities. No problem whatsoever doing this, but will resolutely depict themselves as outside of this political process. And I think actually, I object to that on democratic grounds. in the sense that this creates an unelected aristocratic minority that makes rules for the people. But I think you can also object to it on in some sense on pragmatic grounds, in that it removes the sort of dialogue between all of the branches, and it sort of sets up the Supreme Court as something outside politics. It's one of the branches of a government. And in lots of other countries, the high court that practices some kinds of judicial review is often in direct conversation with the legislative branch, in some kind of in some kind of colloquy where they say, okay, well, we're striking this, but you can add this. And there's much greater dialogue and interaction between these branches, because it's not understood or pretended that that a sort of a life tenured judiciary has nothing to do with politics, which flies in the face of history, as Allen says, and I think only sort of functions to sustain this judicial power and keep it from the reach of just ordinary mortals in politics. So I sort of strongly object to that. Not to jump on the question, Sandeep, but I sort of strongly object to that framing.
I appreciate that, and you actually kind of take me to my next point. I just wanted to jump to the present for just a minute, and ask if Judge Barrett's confirmation should proceed. How do you reconcile the fact that it's, yes, the president's constitutional right to nominate a justice, with the risk of the Supreme Court, kind of just becoming this vehicle for policy decision to be passed through with a 6-3 majority?
Well, one of the difficulties that way is that, as we've been saying in these observations, especially about the Lincoln administration and the Tawney Court, you're going to have questions about politicization no matter what. And sometimes it does depend on whose ox is being gored. There have been judicial nominations all through American history which have been contested on political grounds. Some have been successful, some have not. Tawney himself was an example of this, because Andrew Jackson nominates Tawney to the Supreme Court, not once, but 3 times. Tawney had been Jackson's Secretary of the Treasury. In some respects, Tawney functioned as the executor of Jackson's will in the bank war, because it was Tawney, as Secretary of the Treasury, who agreed to withdraw federal deposits from the Second Bank of the United States, and thus put a period on this thing called the bank war between Nicholas Biddle and President Jackson. Tawney is nominated by Jackson once, he's turned down. He's nominated twice, he's turned down. Jackson goes back, nominates him a 3rd time, this time as Chief Justice, and this time after the death of John Marshall, Tawney is confirmed. So you have a long history of politics working its way through the nomination process. You certainly have it in Lincoln's case. How you disentangle the two, I don't know that there is an algorithm for disentangling the politics. What I do think is that judicial supremacy, while that's arguable in terms of supremacy, judicial independence is a goal that is certainly worth cultivating and certainly worth developing. At least it's an aspiration we should put out there. Do we attain it? No, I wish we did all the time. We don't do it. One reason we do it is because we get very impatient with the legislative process. I mean, look what it takes to get legislation through Congress these days. Many people complain that the legislative process in Congress has become so silted up that if you waited for Congress to do things, nothing would ever get done. So what do you have to do? You have to do an end run around Congress. You go to the judicial branch, because there you can get action much more swiftly. That recourse to the judiciary as an auxiliary legislature has in it tremendous risks, but it's been done time and again. And I think a lot of it is because of the impatience and the disappointment we have with the legislative process. I think if we can't talk about judicial supremacy, I think there's that in some ways is a questionable concept. The idea of judicial independence as operating in a sphere separate from the legislature is certainly worth understanding. But one reason we don't do that, and one reason why we do highly politicize the judiciary, is because the disappointment we have in obtaining results from the legislative branch. One of the responses I have to this, when people say to me, "Oh, I'm so disappointed that there's so much gridlock in Congress," of course, my response is to say, well, yeah, that's the way it was designed. The people that wrote the Constitution were not thinking about efficiency. So gridlock would not take the Constitutional Convention by surprise. I mean, granted, the way the Constitutional Convention operated, they experienced a lot of gridlock even when they were trying to write the document itself. But the recourse, especially in current days, to the judiciary as a way of getting around gridlock, that, it seems to me, that is a really questionable environment. And that's where we start to run into the question of how fast do we want our politics to operate?
I agree to maybe a surprising extent, coming at this from different political perspectives. But I think you know, Sandeep, what you said, you know, will the prospect of the court sort of acting as just another branch of politics. I mean, that's been happening. It's been happening in a lot of different ways since the Second World War. It's been happening under this, you know, sort of court regime, you know, very aggressively. You know, we talk about a decision like Citizens United, which you know, in 2010, which overturned you know, a bipartisan, you know, campaign finance reform act that had passed the Senate, had gotten 60 votes in the Senate, somehow unthinkable today to imagine this, you know, the legislative process actually sort of worked in one instance and just wiped that out. You know, in a 5-4 decision, highly politicized. You know, that's a recourse to using judicial supremacy to obtain ends that could not be obtained, perhaps through the gridlock democratic branches. You see this in labor law with all of the court's rulings against, you know, that have overturned, you know, dozens of state laws, federal laws, and you know, going back to the New Deal era. You see it in all sorts of other regulatory questions. You see it in voting reform, right? The recent decisions, all these 5-4 decisions that you've seen, you know, overturning big sections of the Voting Rights Act and so on. These things could not be obtained by going through Congress. You know, they simply couldn't be. And, you know, and it's not a coincidence that they're all objectives of the political right. And so I worry that we are entering, you know, we have a kind of a crisis of counter-majoritarian rule right now that in some ways is overlaps with, you know, with the era before the Civil War, where you have, you know, you have entrenched forces in the counter-majoritarian parts of the government, that is the Senate and the Supreme Court in particular, which are absolutely part of our constitutional regime, but they are exercising radically disproportionate power in comparison to their actual levels of support with the voting public. And I think it's worrisome. And I think we should aim for something more like judicial independence. But I think in order to do that, we need to first challenge politically the foundations of the current kind of counter-majoritarian constellation in especially in the Supreme Court. I mean, I think the Senate is another issue, but I think the Supreme Court seemed, to be honest, from a sort of a democratic and a constitutionalist perspective, it seems almost like a slam dunk to be able to challenge. Does anybody really think that rule by five, that sort of legislation by 5-4 decision of unelected judges is really the way to do this? I think even a lot of, you know, kind of the original generation of conservative originalists who were so upset at the activist liberal rulings of the Warren Court and the Burger Court have reservations about this. Like Robert Bork and others have said, to conservatives who've been complaining about an activist court, are we now basically to put, you know, to use its powers to obtain the ends that we want now that we have the majority? The answer so far seems to be a resounding yes. So I think that power politics is going to continue, but I guess my plea would be, in some ways, for liberals, for the center left, to sort of stop playing this game that sort of exceeds the court, its enormous sort of magisterial power and its stature outside of politics, and recognize it for a political institution, and think about ways to sort of challenge the foundations of judicial supremacy at its root. I think, you know, court packing is one thing. That's not actually, I think, the best I'm not opposed to it, but I don't think that that will get at the root of it. I think, what Allen said about Lincoln's standard in 1857, this is something that people are talking about again. At what point does the court have the authority to sort of overrule massive, complicated, talk about you talk about Citizens United, or you talk about the healthcare decision. This is a big piece of legislation that the country has been debating publicly for years and has finally produced some legislative fruit. And the court has the potential, depending on how the wind blows, to invalidate the entire thing in a 5-4 decision. Should that standard be higher? Should it require a supermajority of court of justices to sort of actually exercise that kind of, irrevocable judicial review and judicial supremacy? I think that's something that or should it require unanimous? Most Supreme Court decisions are unanimous, in fact, because the legal issues are relatively clear-cut across party lines. Not the political ones, though, not the really consequential political ones. So do we want those decisions to be decided in this way? I think there are a lot of reasons why, at least in theory, the left and the right might collectively agree that this is not the best way to go about things.
I think what a lot of this illustrates is how surprising the definition of the operation of the courts has changed from what the founders might have had in view. The very fact that Article 3 in the Constitution is so vague on the operations of the federal judiciary, and especially the Supreme Court, suggests, at least to me, that they never had in view the kinds of settlements of political questions that Matthew has been talking about. That the reason there's no provision, for instance, like supermajorities on the court in certain decisions, there's no effort even to say, well, in these kinds of decisions, the court has to do this, or it has to do that, or has to do the other. The fact that there are no rules and expectations set out means that the founders really didn't have a particularly expansive view of how the federal judiciary was supposed to operate. That expansive view is something which has developed over time and has developed in a very zigzaggy fashion. I mean, one way of looking at this, for instance, is the decisions that dealt with the internment of Japanese Americans during World War II. In 1942, thousands of Japanese Americans, many of them actually United States citizens, were interned by an executive order 9066 by Franklin Roosevelt. Well, of course, this gets protested into the federal courts, and there's actually a series of 3 decisions which get handed down by the courts between the original executive order and December of 1944. The first of these decisions, this is Hirabashi. The court just says, no, we're not going to do anything to change the executive order. Then you get the second case, that's the case of Fred Korematsu. And there you start to see some crumbling around the edges. And there it's not a unanimous court anymore. Now you've got dissenters. Then you get thirdly to Ex parte Endo late in 1944, and there the court is showing some real hesitations about this internment policy, to the point where in December of 44, President Roosevelt basically cancels Executive Order 9066. So here, within the scope of a few years, you see a dramatic shift in the court itself in response to what are largely political questions, even more than political questions, you might say, in response to a sense of national emergency panic that only by 1944 begins to dissipate, and judges on the Supreme Court are saying, well, I guess the Japanese Empire is not going to invade California after all. So maybe this was a mistake. You see it again during World War II in decisions like Ex parte Quirin, which was another habeas corpus decision. I mean, sometimes the environment of fear, sometimes the environment of politics, whatever, that has contributed to moving the court in a variety of directions. For a long time, the court seemed to be a ratification of a number of liberal initiatives. More recently, it has seemed to be the ratifier of a number of conservative initiatives. There's actually no reason why it can't keep shifting back, precisely because Article 3 really doesn't give us a clear sense of directions and parameters for how the United States Supreme Court is supposed to arrive at its decisions. I don't think that Lincoln's 1857 list of these parameters would probably be adopted with a lot of enthusiasm by the courts today, because they would look at that and say, oh my goodness, that's going to clip our wings completely. To which Lincoln would probably say from some ghostly quarter, and serves them right too. But will we ever move in a direction to limit the courts in terms of this kind of supremacy? Will we ever move in a direction that we could call a Lincolnian direction? I kind of doubt it, because the court itself seems to enjoy this wandering back and forth, the zigzagging back and forth. Comes back again to that question of, here are the branches. We wish they were separate, but in fact, they quarrel with each other, and each is trying to one up the other.
And I'll just say super quickly on top of that, I guess I'm just to be, slightly more optimistic than Alan about the prospect of a Lincolnian vision emerging at some point. I would say, the good news about the very vagueness of Article 3 that Alan is referring to in the Constitution suggests that to clip those court wings, what we don't, enormous procedural, the enormous Herculean work of producing a constitutional amendment is not required. To really change the way the Supreme Court functions, to institute a rule, say, of unanimous or supermajority decision, would simply require the political will to assert and enforce it. If a political party, such as the Republican Party in the Civil War, if a political party had a majority in Congress and simply sort of passed the statute, I don't know exactly how it worked, and we would have to have more. We would have to penetrate this further, and I think this work is starting to be done, in law schools and so on. But it wouldn't. There's nothing to repeal or to adjust in Article 3 in the Constitution itself, or in any of the amendments about about the Supreme Court's power. It's simply our political practice that we afford the court this power. And that political practice, I think, can only be sustained in some sense when both major parties agree to it. And when the Republican Party, for instance, stopped agreeing to it in the Civil War era, that practice changed, and it was zigs, and as Alan says, it zigged and it zagged, and it resettled in a different direction. And I don't think we're even close to there right now, but I can imagine a scenario in the next 10 years where the Democratic Party comes to sort of wonder whether this situation is working for it with the court, and whether it may not be time to sort of think about readjusting those foundations of judicial supremacy. And if that happens, I think we could see another zig or another zag. There will be other zigs and zags. We know that. It's just hard to predict them.
I'm not quite the optimist, because I keep remembering Marbury versus Madison. There could be a political effort to provide more definition, more guidance, and in that respect, more constriction. But at the end of the day, is the court going to go along with it? Is the court going to exercise a Marbury versus Madison kind of power and say, no, we don't think so, we're going to strike that down? Something like that might actually take a constitutional amendment. It would not necessarily need to be a huge amendment. We wouldn't need to completely rewrite Article 3, but we could amend the Constitution, and that would be a solution. But developing the political will and the political firepower to do that in Congress, and then getting it ratified by the states, that's yet another question. And again, my optimism does not surge very highly.
So, Professor Karp, you touched on this briefly earlier, but if Judge Barrett is confirmed, and if the Democrats do take power in both the White House and the Senate, for both of you, in your opinions, should the Democrats be moving to pack the court? Does this set a dangerous precedent of politicization, or does it provide better representation on the Supreme Court?
Yeah, I think these questions are going to be before the public. They already are, I guess. I'm a little skeptical in terms of what will happen. I'm fairly skeptical that anything will happen in the short term. on this. I think so far the Democratic leaders have been really wary to commit to anything, but I'm pretty skeptical. I think Judge Barrett will be confirmed. I mean, this is power politics. The whole thing it's been power politics from the beginning, and Republicans have been better at it lately than Democrats. And so the Merrick Garland case was power politics. This is power politics. I think they have the votes. So, but and I think the Democrats have shown more restraint about in effect challenging these norms rather than the letter of the law in the Constitution, because there's nothing in Article 3 that says they can't Congress may from time to time add new justices. So I actually think, but I think even the way that the language which we're discussing this, pack the court, as if this is some sort of radical extraneous solution, that this is some sort of extra constitutional move to add a justice or two, suggests that it probably won't happen, because I think the moderate wing of the Democratic Party doesn't want to be perceived as rocking the boat in that way. That speaks to the political power of judicial supremacy, that a huge chunk of even the opposition party that is being punished by it in Citizens United, in the Janus case, in Shelby County, and all these Roberts Court cases, has not decided yet, does not feel that it has the political will to challenge it. I believe. I think to get to a scenario where something like that could happen, I think would require the court to this is where the politics of even judicial supremacy, Roberts is very aware of this. That's partly why he didn't want to overrule the Affordable Care Act entirely, because that might have created a more political will to challenge the court's power. So I think even with a 6-3 court, I think that the goal, in effect, for the conservative majority in the court, in my view, will be to do the most they can without tipping over the ship, to sort of exercise their judicial supremacy to the maximum of its capacity without bringing about the counter wave to overwhelm it. So, for instance, but I think if for whatever reason, that's a very delicate line to walk, and if for whatever reason they do make a decision that overturns or rejects some major law, say the Democrats do pass a bit major voting reform bill, that there are plenty of supposed First Amendment grounds or federalist kind of critiques of anti-gerrymandering law from the federal government, or public financing law, or automatic voter registration, something like that, and the Supreme Court says nope, we can't do it by a partisan majority. I think every step that they take along those lines, you just it's just another levering of the antagonism up, and at some point that antagonism may well break out. I do think that the wing of the Democratic Party that rejects judicial supremacy is growing. I think demographically it will continue to grow if you just look at age demographics, and the wing of the Democratic Party that is more willing to sort of forbear these, to sort of overturn these norms in pursuit of power politics, as Republicans have been doing, is also growing. So I think, in the next 10 years, we may have something more like a constitutional crisis about this. I would doubt whether that's going to happen right away in the absence of a perceived court overreach. I don't think the nomination of Barrett is enough. Even though in my view, it should be, Citizens United was enough in my view, but I don't think that's where Congress is right now. I don't know. I'm curious to hear what Alan thinks.
In general, I would tend to agree. I think a number of the most recent decisions over the past 12 months that you've seen coming out of the Supreme Court, decisions which have been surprising from a court which is supposed to be, quote unquote, more conservative or leaning conservative. These have not been what you'd call radically conservative decisions. And I think a lot of it has to do with what Matthew is describing as an urgency on the part of the court not to rock the boat too much, not to invite some kind of dramatic political intervention. And my suspicion is that even with a Barrett confirmation, that is the trajectory you're going to see for the court in the future. Even if you parse the votes as being 6-3 conservative, I think the decisions that will probably get handed down will be nuanced to a degree so as not to trigger a response that could take the form of court packing or some other intervention. So I don't know if that makes me for once sound like an optimist, but it does suggest to me that the court, again, is always looking for what its position is in relationship to the other branches. There's always a navigation, there's always a negotiation that is going on. And like Matthew, I really do not see at this point the political energy there to do a court expansion, or as it's sometimes called, court packing. There's really a lot of resistance to that, principally because what's sauce for the goose is sauce for the gander. You might have a Democratic majority now that's in favor of, let's say, adding 2 seats to the Supreme Court. Well, that would open the door, perhaps 10 years down the line, for a similar but opposite majority to say, well, let's expand it still more with 2 more seats. And then it moves almost ad infinitum. So you have that as a restraint, the court's own sense of itself, and also the sense that if you try to offer a political solution, well, it sometimes is going to depend on whose ox is being gored, and what will solve a problem at one point can have a very different solution with the same mechanism 10 years or even 5 years down the line. So I think I really would be surprised if the future took the shape of some kind of court expansion or court packing. Even Franklin Roosevelt, when Roosevelt threatened court packing in the 1930s, never actually did it. What he got was a response from the Supreme Court that tended to take a few steps back from some of the decisions that it had made about the New Deal, but only a few steps back. It never surrendered its authority, its sense of supremacy. And Roosevelt himself never pushes Congress to try to take that kind of step, because even then he probably would not have been successful in persuading Congress to go along with the court packing scheme. It was great rhetoric. It made its impact on the Supreme Court, on the members of the Supreme Court. But even then, I would be very surprised if there was any real viability to the Roosevelt scheme.
Yeah, I think the value of a court, the politics of court expansion is political as much as it is kind of, institutional. The idea, I mean, the Democrats could add 2 justices and there would still be a 6-5 majority in terms of the current constellation, assuming Barrett is confirmed. So I think, I don't think it will happen, but I think that Roosevelt example shows the way in which the politics of court expansion can be understood as a politics against judicial supremacy itself. And so if Democrats have the political will to make that a serious question, whether or not they succeed in adding justices or not is almost less material than whether they can, in effect, muzzle the court in some way, convince the court to step down. I mean, the New Deal court after Roosevelt's, effort did step back from the Lochner era, which had been, which it had been famous or infamous for striking down all sorts of, regulatory measures. And that's what Roosevelt wanted. He wanted the National Labor Relations Act to pass. He wanted, various other kinds of, progressive reform measures to pass that the court had been blocking for 30 years. And they did let them go. So that would be a sort of a positive outcome of the politics of court expansion, even if there are no new justices added. That's less material. I guess what I would say is my optimism and pessimism on this in terms of my own politics are that I think that the conservative court, I think Allen's right, has shown caution, and especially on really hot button cultural questions. I think on questions of, what we saw, it was the Roberts court that, in Obergefell that sort of made, gay marriage the law of the land. And I think on a number of recent issues, you can also see hesitation to challenge, to sort of overthrow hot, kind of very contentious social and cultural questions. I don't actually think that this court will sweepingly overturn Roe v. Wade, for instance. I think that would prompt a political revolt against judicial supremacy. I think, though, there may be, cuts around the edges, and so on, as people describe them. But I think at the same time, what the court will do more effectively, and what it has been doing, and I wonder whether it will produce the challenge, is, work to basically chip away against that regulatory state that was set up under Roosevelt. That's what the sort of stated mission of a lot of this kind of new First Amendment jurisprudence is about. To say that a lot of these regulatory initiatives, whether they're in labor law or in the regulation of health or insurance or retirement insurance, et cetera, regulation of business, of finance, are violations of the First Amendment. And I would expect the court to sort of consistently rule in that direction. And whether that will provoke a popular and political reaction against it is questionable. I mean, I think it should. I passionately think it should, but I don't know if the political will is there right now on those economic questions, which it makes me a pessimist on my own grounds.
Thank you for that. And just to quickly wrap things up then, I know we've already touched on this with long-term and short-term possible solutions the Democrats could think of. But is this a moment of reckoning for the court? Like, like all this political conflict over it. Is there anything that needs further new consideration?
Oh, that's a hard question for a historian to ask, because you're asking us to think about the future. We usually spend most of our time thinking about the past. I off the top of my head, I cannot say all that I would be willing to say in that regard is, I am not and will not be a nominee for the United States Supreme Court. I won't go any further than that.
Yeah, I've already indulged in far more historical speculation than Alan has been willing to do today. So I'll just continue in that vein and say that I do think I don't think I wouldn't say that it's a moment of reckoning. I think it might be an era of reckoning. I do think that, but maybe every era is an era of reckoning, but by that standard. Yeah, but I do think that over the next 10 years, it will be really interesting. This is not solace to anyone who's really hoping to change the politics of judicial supremacy overnight. But I do think over the next several years, even 10 years, I do think that on the trajectory we're on, a reckoning may be coming. We may be in store for another zig or another zag, as Alan put it. And personally, I hope so.
Okay. Thank you so much for taking the time to talk with us.
All right. It's been fun to do.
It was great. Yeah. Thank you guys for the good questions.
Yes, very good. Very good.